Well, disgorgement, Your Honor, looks at taking the gain away from the wrongdoer. And although this is a large number, it's a large number for a couple reasons. One, because there was a lot of fraud. This went on, and illegality. It went on for 7 years during the statute of limitations period. Another reason is because the guarantee and the financial statements each year worked to get enormously favorable interest rate savings to the defendants. It was a difference of approximately 4 to 8 percentage points, obviously varied by year. That is an enormous benefit that they got from the misconduct. And it is not an excuse to say, well, our fraud was really successful, so we should get some of the money.
Was there double counting in the damages assessed for the old post office and the Ferry Point?
No, there was not double counting, Your Honor. Two points on this. First of all, the interest rate savings and the sale profits are separate pots of money. The defendants got the interest rate savings off the top. There's no suggestion that they invested that savings into the OPO. They were using the loan, and so they got the interest rate off the top. That was the savings that they got. Each year within the statute of limitations, they were getting a savings by doing the fraud over and over again and the illegality. And then the sale profits are separate. And the sale profits, it's not the proceeds. The proceeds of the loan of the sale were around $370 million. The trial court took out the repayment of the Deutsche Bank loan, and I think defendants themselves had taken out already the taxes. And Mr. Trump testified that the number for him, around 126 million in profits, was his profit. That was his profit or more. I'd happy to talk about the statute of limitations quickly, although I see that my red light is on. So,
well, I'll give you more time for.
Sure, Your Honor. On the statute of limitations.
How much? I'll give you 3 minutes.
Thank you, Your Honor. On the statute of limitations, each use of a misleading statement in business and each issuance of a false financial statement is a violation of the statute. And it is helpful to look at the illegality claims. Every time someone issues a false financial statement, that is a crime, and it is no excuse under the statute of limitations to say, oh, although I issued a false statement in 2017, I should somehow, for statute of limitations purposes, be free and clear because I also issued a different false financial statement in 2011.
Is there any tension between your position and our prior decision that said we have to look to the accrual as of the date the transactions were completed?
No, Your Honor. I think the best reading of that language is that the transactions completed. The transaction is referring to the conduct that the statute is referring to, which is the fraud or illegality. So each time you issue a false financial statement, for example, that is a transaction.
I don't think it's referring to the loan.
No, Your Honor. If the court had wanted to refer to the loan completing or the loan initiating, it would have said that. And Ivanka was much differently situated. The problem for what this court said about Ivanka Trump was that she was not sufficiently involved within the statute of limitations for her with the certification, preparation, review, or use of the statements. That was why she was released from the case. Whereas the defendants that remain, each personally were involved in the preparation, issuance, and use of the statements in business. And it would really be a distortion of 6312 and this court's precedent in cases like Allen. A similar thing was happening in Allen, where the original relationship between the counterparties started before the statute of limitations, but then new fraudulent or illegal acts were happening within the statute of limitations. And what the trial court said there, and what this court affirmed, was the new conduct that happened within the statute of limitations is timely and actionable, but the things that happen outside of the statute of limitations are not. And I do want to emphasize that neither the trial court nor the Attorney General sought liability based on the fraud or illegality that happened in 2011 or 2012. That is not true. After this court's decision, the Attorney General was not pursuing its claims for the interest rate differential for 2011 or 2012 or 2013. We were pursuing that before, and because of this court's decision, we stopped. And the trial court appropriately separated it and said the claims that are based on fraud or illegality that happened before 2014 are out. And the ones that happened in the statute of limitations period are in.
Do you want to respond to?
Well, I can touch very briefly on the sanctions, Your Honor. I think for the sanctions, I'll say two things. And one is it was not just one frivolous argument. It was multiple frivolous arguments happening including both at summary judgment, raising the argument that disgorgement is not allowed under 6312 as a categorical matter. That is foreclosed by controlling New York Court of Appeals precedent in Greenberg. And counsel misquoted Greenberg in making that argument to make it seem as if Greenberg had not said what it said. And it was that combined with raising purely legal arguments about standing capacity to sue, raising those arguments again for the third time after the trial court had warned them and said at the motion to dismiss stage, these arguments are frivolous, but I'm not going to sanction you now. I'm warning you. And I understand the need and the feeling to preserve the need to preserve arguments for appeal. As an appellate attorney, I understand that. But what counsel did here was not write a sentence or two and say, for the purposes of preservation, we are adding this to our brief. They wrote the whole argument again, relying on all the same cases and all the same legal arguments without explaining what, as a factual matter, was different, and that was unnecessary and frivolous.
Thank you.
Thank you.
Mr. Sal?
Thank you, Your Honor. Just pivoting to that last point, last year, the Attorney General's office was here on the continuing wrong doctrine, making the exact same arguments. This court rejected them and Trump won, and we're hearing the same arguments again, citing some of the same case law. That was sanctionable for our attorneys in the lower court, but here we are. Now, I want to point the court to two citations in the summary judgment record that I think frame a lot of the questions that my colleague was asked. At 13865, there's unrebutted testimony in the summary judgment record that at least creates a disputed material fact that President Trump would have got the same deal from Deutsche Bank if his net worth had been as low as $1 billion. In their calculation, it was never below $3 billion. So it's triple the threshold. And the clear testimony is the interest rates would have been the same. They held up a chart that would have been on the same pricing chart. So this notion that there were these 8 basis points at issue is just not supportable. Secondly, at 20,042 to 44 of the record and in other places, the Deutsche Bank witness said, we independently assess all these valuations. We are not relying on the numbers that the client is giving us. We do our own independent assessment. That is our due diligence. That's the understanding of the relevant marketplace.
I'm sorry, sir, but
Nordbank.
So we're talking now about cause of action number one, the fraud under 6312.
Yes, and the causation argument as to disgorgement. Yes,
Okay.
Yeah.
So we know point taken, as to the liability on cause of action number one, we know fraud under 6312 has a much broader meaning than common law fraud. And so there it's, as your friend pointed out, the standard is the capacity or tendency to deceive. Did those statements have the capacity to deceive?
Absolutely not, Your Honor, for at least 3 reasons. First of all, they're gap compliant. They're not misrepresentations. All the key things they point to is this was wrong and this was wrong. The unrebutted testimony, certainly in the summary judgment record starting at 17,916, is this is what you do in a financial statement. You are allowed to do this. You are allowed to predict, for example, that you'll get your rent restrictions lifted or you'll get authority for, more units at Aberdeen. You're allowed to do that. You're allowed to make optimistic projections. You're allowed to disregard appraisals. What Professor Bartoff said is that appraisal could be sitting on your desk and you don't have to rely on it. And there's actually really powerful evidence in this case to show why that's true. Because if you look at 40 Wall Street, they said, in 2011 and 2012, the appraisals of 40 Wall Street were at 200 to 220 million, and you said 527 million. But they overlooked that a couple of years later. Cushman revised its appraisal and said it's worth 540 million, virtually matching what we had said, and they say is misleading. So it's kind of these astonishing issues. It's very similar to the valuation of Mar-a-Lago as $18 million based on a tax assessment. It's preposterous. It's a preposterous position that these factual things. So that's my first answer to that. But secondly, more importantly, we have sophisticated counterparties, as a lot of the questions pointed out. They're getting clear disclaimers. The disclaimers say what everybody already knows you do in this industry. You do your own due diligence. So how is there a capacity or tendency to deceive when you have these very clear disclaimers saying considerable judgment is required here? These values don't reflect what might be realized upon a sale and so forth.
But what about the Attorney General's point that may be true in this case, but we are trying to create a fair and honest marketplace, which will inure to the benefit of the public in the long run?
Yeah, and I would say 2 things in response to that. First, all the questions about line drawing. If this case falls on the other side of the line, there is no line. I mean, you heard, I think, for 15 minutes, respectfully, my colleagues struggle to articulate any clear principle that would put any transaction outside the reach of the statute on the Attorney General's very broad and sweeping view. So our position is narrow, which is that on the facts of this case, all these things I referred to, no reliance, no materiality, Deutsche Bank saying we would have given them the exact same deal, and we have clear disclaimers. Surely this is not within the statute. And if this is, there's nothing that falls outside of the statute, and that is a sweeping and unsettling thing. The second point I'd make about that is...
And I'm sorry, just to tie a ribbon around that, do you mean based on the facts as they were adduced on the respective records, the summary judgment motion as to cause of action 1, the trial record as to 2 through 7? Not that the AG didn't have an interest, at least at the outset, in investigating and maybe commencing the proceeding.
We're not disputing that in this
They
case.
certainly have that
You're
interest.
saying once you got all the facts before the court, which
And that may have been, I wasn't on that case, but that may have been the point of our prior decision, which Mr. Isaac brought up, about this being at the pleading stage. Yes, so it was enough at the pleading stage, but at the end doesn't mean this is what should happen.
That's exactly right, Your Honor. Here we have all the facts before the court.
But the pleadings in this case, but the pleading in this case is like a novel. It goes on at length, 327 pages or something like that. And basically, those were the facts that Justice Ngoran found were proved at trial. So aren't we bound by our prior decision? I asked this question another way before.
Very significant variations. I just want to flag one. I see my red light is on. The pleading, the complaint, cites GAP like 50 times. They said these statements are bad because they violate GAP. But you go to the summary judgment record, they have nothing. They don't put anything on GAP. The trial court never cites GAP. Our experts say these are GAP compliant. That's unrebutted. So there's this totally, the record looks totally different once all the facts are in. And I know my time has expired, so I thank the court for its time.
Thank you.
Your Honor, I'm actually going to go under my time. I just have one observation, and I don't know, maybe I'm wrong about this, but this argument, if it doesn't show why not making a summary judgment motion was appropriate, I don't know what is. There was absolutely nothing wrong with what the attorneys did. My adversary said that she's relying on the Ernst & Young case. I read to you what you said. That's exactly what you did. One more point and I'll sit down. Keep relying on Greenberg. This is what the Greenberg court said, Greenberg 2. Initially, we note that defendants may not raise issues on appeal that were not preserved on the record for our review. So even if they're right about what this court said and they're not right, it wouldn't matter anyway because lawyers have to preserve issues for all courts that may consider it. They have to look at things not temporally at the time, but what could happen afterward. And given that, and I'm not, this isn't Brian Isaac or it's not Michael Ross, I'm reading to you from the court. They did what they were supposed to do. They did what they had to do. To sanction them is just wrong.
Thank you.
Thank you.